Hi, I'm Sue Elliott.
And I'm Ed Holland. In this special three-part edition of the Olympia Insider, we're looking into a very complex issue, legal guardianship and its alternatives.
The first part of the series will learn a little bit more about what guardianship actually is. The second part of the series will focus on the many alternatives to guardianship. And then finally, the third will focus on what the individual's rights are.
This series is a part of a project called Informing Families Building Trust, a trusted source of information that you can rely upon. Additional information about guardianship as well as other resources can be found at the Informing Families Building Trust website at www.informingfamilies.org.
To learn more about guardianship, we've spoken with Donna Holt, a private attorney who specializes in disability issues, elder law, and also guardianship.
The Superior Court can appoint guardians of the person, or guardians of the estate, or guardians of both. The guardian of the estate is responsible for assessing the needs of someone's money, investments, allowance, and everything having to do with finances. Guardians of the person are responsible for assessing the individual's social, mental, and emotional needs, making sure the individual's activities of daily living are met. In both cases, the degree of authority the court grants has to do with the particular needs and abilities of the individual. Full guardianship gives the guardian the broadest authority, and the guardian then is responsible for the financial, medical, and social activities of the individual. Limited guardianship has to do, for instance, with just financial needs or just personal needs.
It's important to know that there are certain things a guardian cannot do.
Among the things a guardian cannot do is sell, mortgage, or lease real estate or personal property without the court's authorization. The guardian also cannot sterilize or place a person in a nursing home or institution against his or her will.
The guardianship process is fairly involved, and rightly so. It's very important to assess the individual's needs, preferences, and abilities before determining if guardianship is the best option.
It's actually the courts that determine whether or not a person needs a guardian. They also decide what type of guardianship and also who the guardian is going to be.
Anybody can petition the Superior Court for guardianship over someone else. The petitioner has to ask for either a full or a partial guardianship and ask specifically for a guardianship of the person or a guardianship of the estate. The petitioner also must allege that the individual is incapacitated. After the petition is filed, the court appoints an independent person to investigate whether a guardianship is really necessary. This person is called the guardian ad litem. After the investigation is complete, a hearing is set before the judge. At that hearing, anybody interested in the guardianship can offer testimony. The individual may have an attorney represent him or her and ask for less restrictive alternatives.
Limiting a guardian's power helps to ensure that the individual has as much control over his or her life as possible.
And that's what it's really all about the person with a developmental disability. Tune in for part 2 of this special series so you can learn about the many alternatives to guardianship.
For more information about guardianship or other services, policies, or resources that are important to people with developmental disabilities, go to the Informing Families Building Trust website.
Thanks for watching another edition of the Olympia Insider.